This Supreme Court ruling does not mean we don't have to fight anymore, but it does mean we have more ammunition. That's a definite change. That's definitely saying, look, it's appropriate to set high expectations for students with disabilities. And that's fine. I mean, in the National Federation of the Blind, we're all about raising expectations for blind people. And that includes the accountability that we as blind people and blind students have to do their best to succeed. Going back to the basic example of just accessing the curriculum, a child has to do that in order to be educated. So I think it is going to change the accommodations that school systems provide. If you're receiving an education to the standard of merely more than de minimis, then you're not really receiving an education at all.
You can find more podcasts with a blindness perspective at www.blindabilities.com. Check us out on Twitter at blindabilities and get the free Blind Abilities app from the App Store. That's 2 words, Blind Abilities. Welcome to Blind Abilities. I'm Jeff Thompson. And today we're talking to Chris Danielsen, the Public Relations Director of the National Federation for the Blind. How you doing, Chris?
I'm doing great, Jeff. How are you?
Great. I'm doing great. The Supreme Court just handed down an 8-0 decision in favor of strengthening the IDEA, Individuals with Disabilities Education Act. Can you explain to our listeners what this decision was that the Supreme Court just passed?
Sure, absolutely. This is an incredibly important law that affects the education of blind students and other students with disabilities all across the country. It's a federal law. And the exciting thing is that the Supreme Court of the United States has just issued a unanimous decision that really tells school systems that they need to work harder to educate blind students and other students with disabilities, that it's not going to be acceptable for them just to provide the bare minimum of accommodations so that students can just occupy space in the classroom until they drop out or fail out.
Yeah. Chris, I think what it boils down to is interpretation. I grew up through the ADA and we had the reasonable accommodation, to whom defines reasonable, and now who defines meaningful education or appropriate public education.
Well, the standard under the idea is a free, appropriate public education. So that's the terminology that the idea uses. So it's pretty easy to understand what free means, but the question is always what is appropriate. And what's supposed to happen under the idea is that the school administrators and educators are supposed to work with the family of each student with a disability in order to make sure that that child is getting an appropriate education. And the question then becomes, when the school district and the family disagree, what controls and what is the actual standard that due process hearing officers and courts can apply in determining what is the actual, which side wins, which among the parents or the school administrators has the better argument as to what's appropriate for the child.
So the probable weakness in what was just decided is that it doesn't bring it all the way down to when they sit down to do their IEP.
It doesn't necessarily, although it does raise what families can ask for, I think, because what it does say is that the curriculum has to be appropriately challenging for the student. The school district can't just put a plan in place that allows the student to get by or not get by. It's not a minimal education that they can receive. The standard that was being used was more than de minimis, which, to translate that from legalese into English, means virtually nothing. As long as you're doing something more than just letting the kid sit there, then you're doing your job. And the Supreme Court has now said that's not the standard. The standard has to be that it's a meaningful education. The child has to be able to meet challenges that are appropriate to his or her capacity. And so, for a lot of children, that's going to mean advancing from grade to grade in the case where the child isn't going to advance at the same rate as other students. And that's usually not the case where we're concerned with blind students, unless you've got a child who is blind and has other disabilities, which is something that has to be dealt with. But for a blind student, it's pretty clear that the kind of low expectations that we've seen from school systems in the past are no longer going to be enough, that there has to be a real education happening.
Which is going to raise higher expectations from the teachers and of the students themselves.
I think that's right, and that's fine. I mean, in the National Federation of the Blind, we're all about raising expectations for blind people, and that includes the accountability that we as blind people and blind students have to do their best to succeed. But it also means that the school system has the obligation to provide the services and the supports like accessible textbooks and course materials that are going to allow that success. And I think with this new decision, for example, it's going to be a lot easier to argue, look, if you're not getting the child's textbooks to them on time and therefore not receiving the same curriculum that other students are receiving, then you're not meaningfully educating them. You're not moving them forward, because in order to advance, a student has to have access to the course curriculum, right? That's what makes education what it is. If you're not accessing the curriculum, then you're not really getting educated. So it remains to be seen how courts will apply this new ruling to specific standards. And even in this case, the court didn't rule on whether this particular child, Andrew F., whether his IEP met this new standard. They just said the new standard is higher than more than de minimis. And so now this goes back to the lower federal court to decide, okay, well, let's look at this child's IEP and say whether it really meets this new standard that the Supreme Court has just articulated.
And that kind of goes with kind of like the generic form that they were using time after time, with never setting a standard or never actually looking at if there was improvement.
Right, exactly. I mean, now the court is going to take a much closer look at what the school system was doing and say, were they really doing what they needed to do in order to allow this child to advance? And the parents are probably going to have a strong case because they withdrew their child from the public school and put him in a private school where he is excelling. The real issue is whether the school system now owes them the tuition because they didn't provide what the child needed. So that's what's going to happen now. And I think what the Supreme Court has done is to say, look, it's not enough to do just barely enough to let the child get by. It has to be a meaningful education. I mean, one of the most powerful lines in the ruling says something like, if you're receiving an education to the standard of merely more than de minimis, then you're not really receiving an education at all. So that's, I think, a big change. And the Supreme Court could have done more, but it definitely raised the bar beyond what it has been set at.
Which is really good, because there's so many cases, and this is what it's basically for, is the cases that are going to be going forward from now.
Right.
But it really doesn't implement anything. Like if I go over here in Minnesota right now and set up an IEP for someone, are they going to be looking at that today and change the way they did it yesterday?
Well, yes. I mean, it remains to be seen how this will be interpreted on the ground. And that is a legitimate question. But again, the language in the Supreme Court decision, I think, does give more ammunition to those who are contending that the school district isn't doing enough. How this works in practice remains to be seen, just because, I mean, the idea requires an individualized approach. It requires an approach for each individual child. And that has to be worked out between the school district and the family of the child that's involved. But I think definitely a family, if it feels that the school district is not allowing a child to appropriately advance, has more ammunition now because of what the Supreme Court has said.
And that may have a big influence on administrations and districts when they decide to educate their teachers how to better educate students with disabilities.
Well, I would hope so. I would hope so. And a lot of times it's not the classroom teachers that are even the problem. It's the school administrators, and whether they're providing Braille or whether they're providing orientation and mobility services that are adequate, or whether they're using new technology for the curriculum, whether that technology is accessible. Going back to what I said earlier, in the blindness context, I think we have a lot of ammunition from this decision to say to school systems, look, if you're not even providing, if you're not even providing access to the curriculum, if the child literally can't access what the other students are accessing, that's certainly not going to meet this new standard that the Supreme Court has articulated.
Well, I think it's a great step forward, especially in today's age.
Absolutely. And it really does signal a shift in how people with disabilities are being viewed, because there was a time when it would just have been accepted that, okay, students with disabilities have lower capacity and they're just not going to achieve what other students will achieve. And the Supreme Court is saying, well, that's not necessarily true. Every person with a disability is an individual, and based on what they are capable of, they have to be receiving a real education that is appropriate to a level that they can achieve. And it says that the expectations have to be high with respect to each student, because it says, they've got to meet challenges. It can't be just squeaking by. It has to be something where the child actually is academically challenged by the curriculum and by the plan that's been put in place for him or her. And that's a definite change. That's definitely saying, look, it's appropriate to set high expectations for students with disabilities. Now, it still leaves in place that idea of the individual and what the individual's capacity is. And of course, we're still going to have a little bit of the problem of school systems saying, trying to argue that a student's capacity is lower than maybe what the parents think it is. But that's all stuff that can be, hammered out. The capacity can be tested. And once you've tested a child's capacity and know what they're capable of learning and what their intelligence is and all of that, you've got a pretty good basis for going forward. I mean, that applies to other children, so why shouldn't it apply to children with disabilities?
There's no more sliding through, so the students, prepare yourself because you're going to get challenged now, right?
Hopefully. I mean, again,
and that's how you learn.
Right, exactly. That's what learning is. Learning is acquiring information, progressively more difficult information, and being able to process and use it. That's what the process of education is. If that's not what's happening, then you're not getting an education, as the Supreme Court has said. You're not advancing. You're not doing anything but occupying space in the classroom.
Which is failure, really.
Right, exactly. That's another thing that they point out in the opinion, and that we've pointed out over the years is, look, basically what a lot of school systems are doing is they're just waiting for kids to fail. Let's just keep them sitting in the seat and getting by until they drop out or fail out. And the Supreme Court pointed that out and said that's not acceptable. You're not allowed to let the kid just sit there and occupy space until they drop out or fail out. Because some school systems have done this. They've let students limp along until they become not their problem anymore. And that's unacceptable.
Does this change how people will look at reasonable accommodation now?
Well, again, reasonable accommodation is a different standard that applies in the context of the Americans with Disabilities Act. The standard under IDEA is different. It's a free, appropriate public education. But I think this does change what that means. I think it does say, look, there has to be educational advancement happening. And that means that the child has to have services and accommodations that allow that to happen. So again, going back to the basic example of just accessing the curriculum, a child has to do that in order to be educated. So I think it is going to change the accommodations that school systems provide. We often make the argument with respect to Braille, for example, that while it may be technically true that a child can read print if it's magnified to billboard size, and they're reading basically 2 or 3 letters per screen, or they can only read for 10 minutes at a time because otherwise it gives them a headache and they become exhausted and can't do it anymore. Well, then they're not being allowed to read at grade level. They're not progressing at the same rate as their fellow students. You've got to give them a reading medium that allows them to actually reach those same milestones that the other students of similar capacity are reaching. So I think we can use this in all sorts of ways. Again, where the rubber meets the road is going to be how school districts interpret this obligation. I thought it was amusing that there was a quote from the head of the National Association of School Boards or something like that. And he says, well, we're comfortable with this standard because we're already meeting it. And I was like, yeah, really? Not right. This Supreme Court ruling does not mean we don't have to fight anymore, but it does mean we have more ammunition.
I like that. Very well put, Chris. We've been talking to Chris Danielsen, the Public Relations Director at the National Federation for the Blind. Chris, I want to thank you very much for coming on the Blind Abilities. It's been a pleasure having you, so thank you very much.
All right, we appreciate it, Jeff. We appreciate the opportunity to speak with you, and don't hesitate to reach out to us anytime.
It's always a great time talking to Chris Danielsen or anybody at the NFB Center out there in Baltimore. And you can reach them on the web at www.nfb.org. I'd like to thank you all for listening. And until next time, bye-bye.
When we share
what we see through
each other's eyes, we can then begin to bridge the gap
between the limited expectations and the realities of blind abilities.
The realities of blind abilities.
For more podcasts with a blindness perspective, check us out on the web at www.blindabilities.com, on Twitter at blindabilities. Download our app from the App Store, blindabilities, that's 2 words, or send us an email at info@blindabilities.com. Thanks for listening.